In this video, we would like to discuss about specified dower. So the amount of dower fixed by mutual agreement between the parties to the marriage is otherwise called as specified dower. The amount of the dower may be fixed by the father if the son is minor or of unsound mind. And as it was decided in the leading case, Muhammad Siddiq and Shabuddin in 1927 by the Privy Council, among the Sunnis the rule is that the dower as fixed by the father is binding on the son, and the father has no personal liability to pay it. And in the leading case, Sabir Hussain versus Farzan in 1938, the Privy Council expressed that among the Shias, the rule is that if the son has no means to pay it, the father is liable. And as Baillie, as an expert on Muslim law, and he interpreted the very position of specified dower as it was mentioned in Hidayah, the oldest and the ancient source of Islamic law. So there he found that the Hanafi law, the wife is in every case is entitled to receive the minimum amount of mahr or dower, which was 10 dirhams, even if she has agreed to receive less. But under the Shia and the Shafi law, the wife agreeing to any amount, even less than 10 or 3 dirhams, is not entitled to an amount more than what is fixed, unless the amount is destitute of any value. And as expressed by Ameer Ali, another expert in Islamic law, sometimes it happens that for the purpose of glorification of the husband, a large sum of dower is announced in public, but in private, a moderate amount in accordance with the means of the husband and the status of the wife is fixed. In such a case, the dower fixed in private is the real dower, and that alone can be realized. And as in reference to dirham, it is the official currency of Saudi Arabia. So there would be no confusion regarding the very currency of dirham that already we have discussed previously, and now also we are discussing regarding specified dower. And specified dower is divided into two types. One is prompt dower and the second one is deferred dower. So regarding prompt dower, the prompt is payable immediately after marriage or any time on demand by the wife, while the deferred amount is payable at such time or on the happening of such contingency to which it is deferred, but in every case it is payable immediately on dissolution of marriage or by divorce or death of either party. So, when at the time of marriage it is not specified as to which part of the dower is prompt and which part is deferred. The Shias take the view that the whole amount is prompt as it was expressed by their Lordship of the Madras High Court in Mastana versus Asia Bibi in 1899 by the Madras High Court. Among the Sunnis, the rule is that one part should be treated as prompt and the other part is deferred. So the Madras High Court takes the view that irrespective of the fact whether the parties are Shias or Sunnis, in the absence of any specific contract, the entire amount should be presumed to be prompt as it was decided by their Lordship in Sheikh Muhammad versus Ayasa in 1937. So, also, a full bench of the Lahore High Court held the view that the matter may be determined on the basis of usages or custom in wife's family in absence of usages or custom. The presumption is that one half is prompt and the other half is deferred as it was decided by their Lordship of Lahore High Court in Nasiruddin versus Amatullah in 1948. So also, it is also possible that the proposition may be different in different cases. So, according to the High Court of Bombay, even when the parties are Hanifs, the court has power to award the whole of the dower as prompt dower, as it was decided by their Lordship of Bombay High Court in Fatima versus Sadauddin in 1865. So, now let's discuss the views of Ameer Ali as he found it in the Hidayah, the most ancient and oldest source of Islamic law. And regarding that, the basic distinction between the prompt and deferred dower is this: the prompt dower is realizable and payable at once after the solemnization of marriage, and the wife can refuse all conjugal rights to the husband till her prompt dower is paid. On the other hand, the deferred dower becomes payable on the expiry of the specified period or on the happening of specified contingency to which it is deferred, and in every other case it becomes payable on the dissolution of marriage or by divorce or by death of either party. So, Hidayah in this specific subject expresses this view. So, in the very leading case, Abdul Qadir versus Salima in 1886, the Allahabad High Court expressed that after consummation of marriage, non-payment of dower, even though exigible, cannot be pleaded in defense of an action for restitution of conjugal rights. The rule so laid down having, of course, no effect upon the right of the wife to claim her dower in a separate suit. Mullah, it is submitted rightly says that in such a case, decree for restitution of conjugal right should be passed conditional on payment of prompt dower. So, as it was expressed in the leading case, Revia versus Mukhtar in 1966 by the Allahabad High Court, as it was expressed by the eminent authority on Islamic law, Mullah, show the very distinction between prompt dower and how it differed from deferred dower that already we have discussed in this above discussion. So, our next one would be proper dower.